Consumer Guarantees Act, 1993, for small and medium-sized enterprises. One day, James bought an iPhone at no limit. 2 weeks later, the screen of the iPhone stopped working for some unknown reasons. In this case, what can James do as a customer? And what should No Limit do as a supplier? James can go back to No Limit and ask for a repair. It is important for customers to know the Consumer Guarantees Act and realize that their rights are protected. However, it is also important for businesses to know the Act as well. Businesses need to be able to tell their staff what the Consumer Guarantee Act covers. At the same time, No Limit staff should have to know whether it is their duty to get the phone fixed. If the business does not have a clear understanding of the Consumer Guarantees Act, it could cause a breach with the Act and mislead customers. No Limit in the past has been fined $20,000 for misleading customers and for not fulfilling their duties to customers. They have made defensive claims such as making claims under the CGA about an iPhone had to be negotiated with Apple, claiming the CGA is not effective for No Limit, and telling a customer they weren't entitled to a refund despite false representations made. What is Consumer Guarantees Act? Who does the CGA apply to? The Consumer Guarantee Act applies to consumers, suppliers, and manufacturers. Who are consumers? A consumer like James is a person who acquires goods or services from a supplier that is ordinarily acquired for personal, domestic, or household use of consumption. Acquiring these goods or services can be done through purchase, gift, exchange, lease, and hire purchase. What guarantees are given to consumers? There are 6 main aspects given. Firstly, acceptable quality. Secondly, fitness for a particular purpose. Third, good must comply with description. Fourth, goods must abide by sample or demonstration model. Fifth, repairs and spare parts available by suppliers. And 6, express guarantees from manufacturers. There are some remedies business need to face when consumers are not satisfied with its goods or the services they got on the basis of those guarantees above. Businesses would need to choose to fix or replace the goods. If the business finds that it is too difficult to fix, or a remedy cannot be made without a reasonable time, then the consumer has the right to reject the good and claim for a refund or replacement. If you are a manufacturing business, consumers can claim damages when goods do not have acceptable quality or fails to match the description, or that no appropriate repairs or spare parts are available. If the consumer is told about any defects before the good are supplied by the manufacturer, then there is no breach in the CGA as to whether a good is in acceptable quality or not. There is only one circumstance where both parties can contract out the CGA. It is when there is a business-to-business transaction. Both parties of business are in trade. They need to have an agreement that is in writing, and the term of agreement must be fair and reasonable. If the consumer is a non-trade business, then the supplier, also a business, which attempts to contract out the CGA with the consumer would face a breach of the FTA. It is essential for a business to have an understanding of the Consumer Guarantees Act. When it comes to an issue of the customer claims of guarantees with the good they acquired, it is important for a business to identify whether it is a duty of the customer, the business itself, or a third party, such as manufacturer. It would help protect business own rights and prevent breaching and misleading behavior from it happening.